today at NCA's Guide.
Foundations of Canadian law. In this class, what we will be doing is to give ourselves an overview of the course, take us through the syllabus. Recently, the syllabus has been updated for the 2022 examinations. And that's why I will tell you straight away, if you want to write foundations, you should just write it and move on with it. Because more than any other course, the syllabus are revised for foundations more than any other course. There is a 2021 edition of the syllabus. Probably that was the one you were reading. Before this update to 2022. Before then, there was an update in 2020, right? And before then to 2019, there was an update. So what we've noticed, the trend that we've seen in recent times is every year they update the syllabus. So in that regard, I will encourage you to read or take the course as early as you can, because you can, if it takes you too long to prepare for it, they can just change the syllabus abruptly, and you just basically start from where you were. So I'll just share my screen now so that we'll see the 2022 syllabus. Just a moment. Yeah, I didn't introduce myself. My name is Masud Balogun. I will be your guide for the foundations of Canadian law. So can we see my screen? Can we indicate that we can see my screen? Anyone?
Yes, I can.
Yes.
Okay. Yeah, so syllabus foundations of Canadian law revised for 2022. So this is the 2022 edition, and very important. Please print off the syllabus, and yeah, it should be your Bible. It should guide your reading. And as much as possible, make your notes on the syllabus. What I encourage students to do is on the cases, beside each of the cases, just write the central point, the summary, just maybe 1 or 2 lines to say this case is about XYZ, that case is about whatever the case is about, a very short summary beside the cases in the syllabus. So when answering the question in an exam scenario, you always refer to the case or to your summary, and you can build on it once you had you have read the cases in full previously. So what is the objective of this course, right? So the objective of the course is really to give you an overview of the Canadian legal system. So, and we mentioned earlier that you will see when you're going through other courses such as constitutional law, admin law in particular, constitutional law and admin law in particular, you will see you will see some of the things that you've read under foundations under these courses as well. So the objective being that the foundations of Canadian law is to give you a general overview of the Canadian legal system. So give you an introduction. Think about when you were at the university, when you did legal system. So that is what foundation is about. Introduces you to the framework, or gives you an overview of the Canadian legal system. One other objective of the course is to introduce certain concepts to you, so legal theories, and things like constitutional basis for the Canadian law, things like sources of Canadian law, like in similar to common law jurisdictions, the sources include the common law, the doctrine of equity, international law, and all that. So it introduces you to the sources of the Canadian law as well. So one other objective of the Canadian of the foundations of Canadian law is to highlight the special relationship between the Canadian state and the Aboriginal people of Canada, and we'll deal with that in chapter 2. So the special relationship between the Canadian state and the Aboriginal people of Canada as well. So one other objective you'll find in the Canadian foundations of Canadian law is to give us an idea of the principles of interpretation, how our decisions or statutes interpreted, So what you will see concept like bijural interpretation. I think we'll deal with that in chapter 3, bijuralism, so meaning that Canada has both civil tradition and common law tradition, and how this plays out in the interpretation of the law or of the constitution and in the decision of the courts. One other objective of the course is to introduce you to the functions of the different arms of government in Canada. So you will find that we have fusion of the executive and the legislature in Canada, because Canada operates a parliamentary system of government. The prime minister, for example, is a member of the parliament as well as the head of the executive. So how does that work? So in system that operates a presidential system of government, for example, whether in the US or in Nigeria, for example, you have complete separation of power between the executive, the legislature, and the judiciary. But in Canada, while the same person can be exercising both executive and legislative power, as I gave in the case of the prime minister or cabinet ministers, for example, who are members of the parliament but are also cabinet ministers who are members of the executive. So we will deal with that as well. We also deal with, equitable doctrines, so and how that affects the interpretation of laws in Canada. We also talk about the treaty making process, how customary international law is part of Canadian law, and how that is also implemented in Canada. So the principle of dualism. So does international law or treaties, does it have to does it have to be domesticated before it can be implemented, or does it apply by the force of its own? So we'll also talk about the structure of judicial review. So how do courts review the decision of administrative tribunal? So what are the considerations that they do have while reviewing administrative decision made by administrative tribunal, and what is there a limit to their review? So can the court just substitute its own opinion with that of the administrative tribunal, or there should be some level of deference to the decision of the administrative tribunal? So those are some of the concepts that we'll be dealing with under this course. One thing we'll note in foundations, in terms of from an exam perspective, is that the exam can be in different types, basically like 3 types or so. So you have short answer questions. So it just more like OBJ or objective. It's a yes or no answered. So it's either you know it or you don't know it. So they can ask you very straightforward answer, question that requires you to just provide one answer, you know. So then one other type of question that they ask is essay question. So in which case they want to test your understanding of the of the law or of legal principles. So they can ask you to write an article, or for example, or write a memo. They usually call it memo, not article. So write a memo on a particular on a particular subject, maybe on legal theories or positivism and things like that. Or another type of question is a problem question, whereby they create a scenario and ask you to use legal principles to sort of solve the problem, you know. So you now basically apply your general understanding of the course or of the materials to respond to the question. So in terms of materials to consult, so the syllabus recommended forces, which is forces DUDEC on cases commentary and analysis, the fourth edition. So I like the book a lot. It's very relatable, simple, or easy to read, although the prints are small. So yeah, but if you can read the that material, it will be very helpful. Otherwise, there are other materials all over the place. People have summarized the textbook, people have summarized different materials. You can also rely on that, whatever is convenient for you. We use Manuel's notes, so which has also been updated with the 2022 edition. So it can serve as a guide as well. We can also give summary notes, you know, in classes. So yeah, so what I do encourage students to do anyway is to focus on one material. So maybe at the beginning you can have different materials to try to understand what is the most relatable material for you. But once you determine that this is the one I like, I would encourage you just focus on that, because if you have too many materials, that could be confusing as well. So another reference material recommended is the Canley resource. So there the cases have been reported there, and you can some of the cases, the beginning part summarizes the essence of the case, and you will be fine if you just read that beginning part. But some other, they haven't done that, so you need to now sort of sift through the materials and see what is the relevant area for you. But I mean, Canley is a very good resource. So that's the textbook and Kali and there are other supplemental materials recommended in the syllabus as well. But I believe that if you familiarize yourself with forces and all the cases in Kali, you should generally be fine. Any questions so far? Any questions so far? Someone should say something. Zainab, I haven't heard your voice. I think I haven't heard from Zainab and Successful. Hello.
No questions so far.
Thank you. Yeah, can I hear from Zainab? Okay, so we'll just go through the contents, you know. So chapter 1, what we'll do in this class is to we'll try to run through chapter 1 to 10. just to give a general overview of what the chapters are talking about. Of course, as the name suggests, there is introductory, so we are not going to delve into any granular detail. In the intensive classes, we'll get to that. So the chapter 1 talks about basic theories of law, racism, and the law. Basic theories of law, racism, and the law. So the first point, or the first let me just project my screen. So do we all have the syllabus?
Yes.
Okay,
Yes.
thank you. So the chapter 1 so talks about basic theories of law, racism, and the law. So talks about positivism and natural law, feminist perspective on law, critical legal studies, law, and economics. So does anyone have an idea of what positivist school of law is? Just any whatever you, or your conception or understanding of what positive school of law is. Does anyone want to just share with us? Any volunteer? Please, someone should volunteer. Yeah. Okay, I'll volunteer if no one is volunteering. Okay, so I mean, the positivism just says that law is what is written, what is in the book, so that the validity of law does not depend on its moral content, but rather on what has been legislated upon by the parliament. So whether a law is good or bad is not what makes it to be the law. The morality of law does not determine the validity of the law. That is what positivists say. So positivists generally say that the existence or content of law is a matter of fact and does not depend on the merits of that law. So whether something is a law or not is whether it exists, whether it has been passed by the legislature or by the parliament, or whether it is a delegated regulation made by the executive. So that is what determines whether something is law. It does not, irrespective of whether that thing is moral or immoral. So we'll see the example of given in the textbook in the cases of Drummond Rain and Noble and Wolf. In those cases, in one of them, there was a covenant in a lease agreement that says that land should not be sold to certain group of people, to the Jews, specifically to the Jews and all that. So, and that clause was taken to the court, and the courts struck down that law on the basis that it was an immoral law, and that you can't have a law that expressly discriminates against a particular a racialized group. So when you have a provision in a clause, or when you have a clause in a contract that expressly prevents the sale of land to certain people, then that kind of clause cannot be is unacceptable, right? So the court struck down that provision of the law. What was the consideration of the court in that case? The consideration was that you cannot have a law that is discriminatory, and the court was looking at a moral perspective of the law to come to a decision. While in the second case, Noble and Wolf, a similar clause was upheld by the court because the covenant provides that land should not be sold to non people that do not fall within that the existing community. So and the courts ruled that, look, it is a provision of the clause. Sorry, it is a clause in the agreement which parties have accepted to be bound by. So why would you now seek to strike down a provision of an agreement that you've agreed to be bound by? Before you bought the plots, you agreed that you cannot sell the plots to outsiders. So why do you now want to rely on morality to say that you can sell the plots? So in that case, what the consideration of the court was what the parties actually agreed, irrespective of the morality. So what the two cases tell us is that different considerations inform the interpretation of the law at different points in time. So the same provision can be interpreted differently based on the social circumstance at the different point in time. And irrespective of how those things are interpreted, they do not. What is most important is that law, for something to be a law or for a provision of an agreement to be effective, it does not have to be moral. So it's a matter of fact and not merit. And that is what positivism and naturalist school of law talk about. While a positivist say that law does not have to be moral before it can be regarded as law, the naturalists believe that for something to be a law, it has to be moral, and that a law that does not reflect the moral aspiration of the people cannot be a valid law. That is what the naturalists believe. So that every law has to be rooted in morality, and we see the influence of morality on law. Laws on against adultery or fornication, for example, they are all influenced by morality. So moral is also very important to the law, and that's why the naturalists, they believe that if a law that is neutral to morality cannot be a valid law. But positivists do not believe, do not have the same belief. They believe that whether something is law or not does not depend on morality. You should also know that the positivists are not saying that morality is unimportant or that it is irrelevant to the construction of the law, but they are just saying that for something to be law, it does not have to be influenced by morality, so that the validity of the law and the morality of the law are two different concepts. So, and we'll see this in the course material. One other thing that we also find here is the evolution of the law. So in the case of Edward and Canada, for example, it is called the person's case, which deals with the ability or the qualification of female to the parliament, to the Senate. If you look, when we look at the provision of the Constitutional Act, it seems to suggest that it is only male that can be appointed into the Senate. So in that case, in Edward and Canada, that provision was challenged to say, based on this based on this provision of the Constitutional Act, can female be appointed into the Senate? And the courts, review the law and say we should not look at the law as static, that the law should be interpreted from the point of view of a living tree, to say that when a living tree means that it will grow and it will evolve over time. And this speaks to the concept of feminism and the law, which is also something that is discussed in the syllabus. So after the positivist and natural law, the second concept that was discussed is feminist perspective of the law. Here, it looks at how traditionally law has been used or interpreted to the disadvantage of the female. That all the laws over time, they do not create, they do not take cognizance of the special circumstance of the female. So you have things like abortion law, which really doesn't care about why a female might want abortion, for example. And that's related to as well to the person's case, which is Edward and Canada I was explaining earlier, to say when they were drafting the Constitutional Act, they drafted it with a masculine language, as if female cannot be appointed into the Senate. So the feminist perspective of law, what it does is to say, let's look at the law over time and how it has been used as an instrument of oppression against the female, and let's correct this by interpreting the law in a friendly, in a female sensitive manner, such that wherever a masculine pronoun is used, for example, you can interpret it to include feminine pronoun. Yeah. Also, wherever a law appears to be restrictive of the rights of women, it's either you repeal that law, or you interpret it in such a manner that is sensitive to the peculiarities of the female. And that happened in the Edward and Canada case, where the law was the provision of the Constitutional Act dealing with appointment of members to the Senate, which used masculine language, was reinterpreted to include feminine language as well, to say why the pronoun uses masculine, it does not prevent the appointment of the appointment of female to the Senate, relying on the doctrine of living tree. So the law on abortion has also been reinterpreted to mean that when you disallow abortion, it contradicts the charter principles, which guarantees security of the persons. So that the female should have independence and power over their own body. So they should be able to decide for themselves whether they want to carry a pregnancy to maturity, or they do not want to carry the pregnancy, or they don't even want to be pregnant at all. So those are evolution of the interpretation of the law to take into consideration the lived experiences of people, particularly the female, right? So another issue or topic discussed in chapter 1 is critical legal studies. And what critical legal studies basically talk about is how law in practice reflects our practical and social experience and prejudice, so that in real sense, there is no law that is neutral. You can have a law that is cold, written in a cold language, but it's our lived experience and our circumstance will always influence how we interpret the law. And that law in the book, right, is different from law in practice. So if you have a case before a female judge, for example, let's say you have a rape case before a female judge who has also experienced or knows somebody directly who has experienced rape, or for example, you see that our experience will play in how the case would be decided. So if you have a black judge, for example, who has suffered racism, black racism, or you have not just black, just a racialized judge, like let's say an Arab judge, a Caribbean judge, or an Asian judge, who have all experienced racism in one way or the other, it will influence their understanding or their application of the law of human rights law, for example, in a particular case. On the contrary, if you have a judge who has no experience of racism, who has always been privileged, like a white judge who does not even understand what racism is, that experience will also influence their determination of cases brought before them, such that if you say that you've been discriminated against in your workplace, by maybe someone has written inappropriate thing on your desk, and you that becomes a subject to litigation and is brought to court. The judge may not understand. He can just say, oh, if someone has written something on your desk, why don't you just clean it, just wipe it off, and that's the end of the story. He can oversimplify it because he has not had the experience or that you've had. He's not experienced any form of racism or discrimination and what have you. So he might not necessarily understand or appreciate what you are going through at a particular point in time. So again, in summary, what the critical legal studies tell us is that law in the book, is different from law in practice, and that at all times we should pay attention, or judges or policymakers and leaders, they should pay attention to the peculiar circumstance of people and take into cognizance their lived experience in arriving at a decision at every point in time. So so another concept to discuss is law and economics. And what this does is it applies basic economic models to legal rules and policy in order to assess whether they will result in outcomes that are efficient. So, meaning basically that you will not, Parliament will always make law in an efficient manner using a economic principle of efficiency, such that they might not be able to address all the issues that are before them, but they will seek to address the issues that are most important, that affect the people the most. And also to note that when legislature or when parliament make law, they might not necessarily have altruistic objective in mind. They will make law that will maximize political benefit for them. So when you are reviewing a law, you should have this at the back of the mind. You should not always think that parliaments making law because they want they love you or something like that, but rather they will make law that maximize political advantage and benefit for them. So economic theories also play a big role in the enactment of law. So, for example, things like contract law, family law, property legislation, and those kind of laws, economic principles also play a big part on how these laws are made. So, for example, when you talk about law of contracts, so the principles of offer, acceptance, consideration, unjust enrichment. For example, unjust enrichment in particular, you can also find that in economics to say if you have you cannot use your own wrong, to enrich yourself. So you can't benefit twice or in the same circumstance. So those concepts as well when drafting property legislation, or family law, economic principles are also taken into consideration. So let's give example of family law. Let's the equalization principle, for example. So when there is a divorce, and the family property is to be divided, and the equalization principle comes in terms of how the court will look at what is the economic contribution of both parties to the marriage. So even though one party might not be working, maybe they are taking care of the kids, the court will put value on the time they spend in taking care of the kids to determine what should how the equalization distribution should be applied. So all those are economic theories that also influence the law one way or the other. So those are the theories of law or that were dealt with in the syllabus. So the other materials that were referred to are and Morris, Canada and Keeley, R and Gladway, and the article Arrested Injustice. So just very briefly, R and Morris talks about the fact that the court should always consider the experience of Black people, and in making a judgment or in arriving at a decision in matters that relate to Black people. So while that should not be the ultimate factor, but if someone has been a victim of racism, and that has led them to commit a crime, for example, so the court should look at the impact of racism on them, and how that has sort of led them to commit a crime. So if someone is not being employed, for example, because they are Black, or because they are Asian or what have you, if they are being discriminated against and they cannot find a means of livelihood just because of their racial background, and they now that's led them to commit crime. So the case says that the court should consider that racism or that discrimination against them in arriving at a decision. While in Canada and Shepherd, so what the court referred to in that case is that it was a case that dealt with landlord and tenant. The landlord didn't want to renew the rent of the tenants because just because the tenant was Black, right? And the court ruled that, look, to the extent that the tenant was paying as at when due, they are not owing you. You cannot just evict them because you don't like their faces. So basically, saying that the court should consider anti-racism or racism sentiments in arriving at a decision. So in Aran Gladue, the court refer to section 718 of the Criminal Code to say that in sentencing an Aboriginal offender, the court should consider their historical background, their experience in residential school, the fact that they are conscripted to reserve, and all the difficult experience that the Aboriginal people have had. The court should consider them before sentencing them, and the court should, as much as possible or to the extent possible, avoid imprisoning them. So if they can pay a fine, for example, the court should opt for that. If there is an option of less than 2 years imprisonment for an offense, the court should opt for that. It should just consider the lived experience of the Aboriginal people and the fact that they constitute a majority of the racial group in incarceration. So the court should also consider that in sentencing Aboriginal people. But that is not to say that if they commit very grievous offense, and it is deserving of imprisonment, they should not be imprisoned. But that should always be as a last resort. So that's what the case talks about. Then the article of arrested injustice, quite an interesting article, just summarized or elaborated on the cases of Aaron Morris and Canada versus Cale, which so the article started by talking about the history of slavery, how the black people were colonized and enslaved in the first place. And over time, when they began to live in European countries and the Americas, they began to clamor for their own freedom. Some of them escaped from from slavery, and when they escaped, their lord started looking out for them, and such that when they see a black person in the bus, so they will believe that you escaped from slavery and try to size you up. So this over time became the norm, such that when there is black people became associated with crime, up till today, the statistics in Ontario, for example, is that a black person is more likely to be stopped by the police than a white person. So in terms of the ratio, I can't remember the numbers now, that I think the ratio is like 10 to 2 or so. So the police will have stopped 10 black people before they stop 2 white persons. Such a ridiculous ratio. There is also this aspect of carding in that is used by the police in Ontario, which has been outlawed by the court anyway, where they just have a data of black people and sort of try to associate them with one form of crime or the other, and they are always patrolling areas dominated by black people more than anything else. So, and what he also says is that if you this thing is more like a self-fulfilling prophecy. So if you are looking for crime in only black communities, you are going to find crime in those communities. So And that is not to say that there are no crimes being committed in the white communities, but it's because where you are looking for crime is in the black communities, you are going to find crime, So when, for example, you only stop black drivers and you don't stop white drivers, so you are going to find that black drivers, maybe they don't have license, or their license is expired, or their insurance is expired, or what have you. But you are not going to find in white communities because you are not even stopping them, So the article talked about how that is also reflected across the various level of government, or various arms of government, So even in the judiciary, for example, you find that when in a bail hearing, the court is more likely to implement or impose stringent condition than on a black person than a white person, So in imprisonment, the court is more likely to impose a longer term of imprisonment on a black person than a white person, So at the police level, when they want to grant administrative bail, the police is more likely to impose stricter bail condition on a black person than a white person. So you just see this racism all over the place. And what the article is saying is that we have to do better, right? And pay particular attention to the historic discrimination against the black people, and positively or proactively address those issues. So that's the summary of chapter 1, and we'll see in the intensive class we'll elaborate more on each particular topic. Do we have any questions so far?
None for now.
Okay, thanks, Abigail. Any other comments? Do we have any comments? Anyone? Semi, Zainab, Successful, Sheson?
None from.
Okay. No worries. So we go to chapter 2, right, which talks about indigenous people and the law. Indigenous people and the law. So the indigenous people of Canada, for those that have done either admin law or constitutional law, you'll have read about indigenous people, so they are the pre-European inhabitants of Canada. So those that lived here before they were colonized by the European, So, and then when the European people came, they sort of uprooted their culture, their legal system. So what the chapter is talking about is that before the advent of the European, indigenous people had their own legal system. They had their own culture, and that culture or that legal system should be given consideration in modern day Canada. And the article talks about the chapter talks about Section 35 of the Constitutional Act, which sort of now entrench the right of the Aboriginal people, to say the right of the Aboriginal people is hereby recognized and affirmed. So, which is a major change to how the indigenous people were being treated prior, to say yes, we have to recognize that these people had their own culture, they had their own legal system, and when the European came, they entered into treaties with them, with the Aboriginal people. Some of these treaties were oral, some of them were not also very elaborate, maybe just summary, and because the European were obviously more sophisticated than the indigenous people at the time, so the European protected their own position better than the indigenous people would have protected their own position. So the Constitutional Act of 1982 now brought to fore the importance of recognizing the right of the Aboriginal people to say their fishing rights, their grazing rights, their farming rights, their cultural rights, and all those things, whether or not they are written anywhere. The Canadian state recognizes the existence of those rights. Also, their title to land, is also recognized and affirmed by virtue of Section 35 of the Constitutional Act to say whether those titles were by virtue of land claims agreement or they are not they were not written in any agreement. It's to the extent that there is proof that those land is occupied is owned by the Aboriginal people through whether the exercise of ownership rights over those land and even adjoining land. So they might not have exercised ownership right over a particular land, but even if once it is established that the the Aboriginal people used to exercise right over adjoining land, maybe they used to pass through that land to another place. So that's their title over those land was also recognized and affirmed by virtue of Section 35 of the Constitutional Act of 1982. The other thing to note in the chapter is that Aboriginal matters, things that affect the aboriginality of the indigenous people, is dealt with by the federal government under Section 91, sub 24 of the Constitutional Act of 1867. So while provincial law of general application will apply to the Aboriginal people, but things that deal with the that is specific or that deal with aboriginalness of the indigenous people are under the exclusive jurisdiction of the federal government. So we'll see a number of cases here that deal with the Aboriginal people. Some of them are not have not been referred to in the syllabus, but if you read the course materials, you find them there. So cases like the Aaron Sparrow, Aaron Vanderpeet, so Sekoti Nation, things like cases like Haida Nation and BC, which deals with the honor of the crown, and we'll now dig down what does the honor of the crown mean. So meaning the honor of the crown, for example, means that the crown has to deal with Aboriginal people with good faith. It can't be on the basis of strictly on rights to say we are in the right and you are in the wrong. No, the Aboriginal people have to be dealt with good faith. The crown has to deal with them in good faith and as fiduciary, because the crown is more like a trustee or a fiduciary to the Aboriginal people. So a number of articles here, the John Burroughs article, which basically talk about how the Aboriginal culture can fit into the modern Canadian society. He told a story of around that to say, let's not think that Aboriginal culture is backward. There are vital lessons that we can learn from the Aboriginal culture in terms of how they organize their community, how they organize their society, and all that, you know. So in the same vein, the article "Judicial Reasoning Across Legal Orders: Lessons from Nunavut" who also talks about the fact that while we've always talked about respecting the rights of Aboriginal people and the culture of Aboriginal people, in reality, it is different. You know, to say that what the cases have suggested is that the courts do not take account of the lived experience of Aboriginal people in arriving at a decision in sentencing, for example, you know, so that judges must take into account Canada's history of colonialism, residential school, you know, and that judges should also in sentencing, for example, judges should also take this into consideration. So more like emphasizing or elaborating on section 718 of the criminal code, you know. So we say that in sentencing Aboriginal people, the or Aboriginal offenders, the court must take into consideration their experience and what have you. So there's also the article, the summary of the final report of Truth and Reconciliation Commission of Canada, honoring the truth, reconciling for the future. Quite a lengthy document, which was a result of a Truth and Reconciliation Commission set up by the Canadian government, you know, to sort of reconcile the Canadian state with the Aboriginal people, you know, and that commission chronicled the experience of the Aboriginal people, you know, their experience through the residential school, and which sort of led them to crime, you know, and the fact that, for example, they were not allowed to speak their language, they were not allowed to practice their culture, and how that has affected their psyche, you know. I mean, some of the and we saw in recent times graves discovered in former residential school sites, you know. So just telling you how difficult it was for the Aboriginal people and what needs to be done in order to reconcile the Aboriginal people with the Canadian state. And this is why we are studying, part of why we are studying this Aboriginal law, you know. So in foundations, as we are studying now, you find Aboriginal subject. In constitutional law, you find Aboriginal. In admin law, you find Aboriginal. In criminal law, you find Aboriginal topic as well. And I mean, for some of our kids that attend schools, you will see that they discuss Aboriginal subject as well. So it is part of the Truth and Reconciliation efforts of the Aboriginal of that commission for us to know whether you are an immigrant or you are a Canadian. You have to know about the experiences of the Aboriginal people. You have to know about their culture. You know, have to know about their rights, about their title, and all that. In order, so that it can give you a better background of relating with them. And if you live in this country, you will encounter Aboriginal people one way or the other. So if you are a lawyer, for example, if you are practicing and you want to take on an Aboriginal person as a client, so you need to know their own peculiar circumstance in order to sort of understand them and advise them appropriately. So it is part of that Truth and Reconciliation Commission to know about the Aboriginal people and to deal with them in a respectful manner, and give consideration to the fact that they were here prior to prior to the Europeans. They own the land. So you have to give you have to respect that as well. And in terms of, apart from sentencing, even in when the court is dealing with cases, there is a case that we would also deal with in the article, where the issue was jurisdiction. The dispute was between a land bordering both I think Quebec and what's the other province? Was it Ontario or Nunavut? I can't remember now. So and the issue was now which court had jurisdiction. Was it a Quebec court or the Nunavut court? And the case was brought before a Quebec court, I think, and the other side raised that objection that the Quebec court did not have jurisdiction to hear the case. And what the court said is that when you are dealing with Aboriginal matter, issue of technicality is secondary. What is most important is what is the substance, what are we dealing with in this matter. So whether it was brought before the appropriate forum and what have you is secondary, to the extent that there is the court before whom the case or before which the case was brought can exercise jurisdiction one way or the other, then the court should hear it and not be bogged down by technicality. So those are some of the special consideration given to the Aboriginal people as well. Then there is this case as well of the First Nation and Family Caring Society of Canada versus Attorney General. So what the court held in that case is that if you any education system, that did not take consideration the special nature of the Aboriginal people, that doesn't teach them their culture, that doesn't reflect that in the syllabus, in the learning of the Aboriginal people, there is a breach of their rights, so that in educating the Aboriginal people as well, it is a fundamental right for them to be taught about their culture, about their tradition, and what have you. And any system organized by the government or that does not take particular cognizance of the right of the Aboriginal people to learn their culture and their tradition and what have you is a breach of the rights of the Aboriginal people. Then the UNDRIP, the United Nations Declaration of the Rights of Indigenous People, also a very important material which has now been domesticated by Canada as well, is recognize the right of the indigenous people, generally worldwide, and so not just in Canada, worldwide, that the indigenous people, they are not they have the right to their own culture. They are not the Europeans are not better than them, and a whole lot of declaration in that instrument. So we would go through that in additional details as well. So in terms of Aboriginal rights, some of the cases referred to is Chippewas of Thames on First Nation versus Enrich pipelines. This deals with the duty to consult the Aboriginal people when the government is taking any or embarking on any action that affects their rights to the land, for example. So if the government needs to consult them, and to the extent possible accommodate the Aboriginal people. And in that case as well, it was held that an administrative body can consult on behalf of the government, while the duty is on the crown itself. An administrative body set up by the government can also take on that responsibility. So the same position was held in Clyde River versus Petroleum Geo Services, to say that a regulatory body, set up by the government, can consult on behalf of the government. It doesn't have to be the government, as in the cabinet, that we consult. A regulatory body or administrative body set up by the government can consult on behalf of the government, can consult the Aboriginal people. So the most important thing is that that consultation should take place. So does it mean that the demand of the Aboriginal people should be met? Not necessarily so. It might not necessarily be met, but that consultation must occur. Yeah. So the other case referred to in the syllabus as well is Restol versus Canada. uh, which dealt with payment of some royalty to the Aboriginal people for use of their land by the crown. So in particular, I think $5 was fixed many years ago. I think in 1850 or thereabout, a $5 royalty was fixed, and the government has not reviewed that clause since then, notwithstanding that there was a revision clause in the agreement. And the court ruled in that case that, look, I mean, part of the fiduciary obligation of the government is to always be fair to the Aboriginal people. That $5 paid as royalty for more than 200 years ago. I mean, you can't be saying the same sum will be applicable as at this time. So just basically highlighting the need for the government to be fair to the Aboriginal people. Any questions so far? Okay, so I'll just proceed. Okay, thank you. So in Mikisew Crew and Canada as well, it's emphasized that duty to consult that we've been talking about does not arise in legislative action. So if the parliament wants to enact a law, for example, they do not have to go and consult the Aboriginal people in order to make a law. So it is only even though that law will affect Aboriginal people, that duty is not imposed on the parliament. It is only imposed on the executive, such that if executive action will affect the Aboriginal people, there is a duty to consult, but that is not the same for legislative action. So in Paston and Dean, the courts ruled in that case that judicial review of Aboriginal matters should be on the basis of reasonableness. And this will make more sense when we get to chapter 10 about the standard of review, correctness, reasonableness, and what have you. So meaning that once the decision is logical, when there is some reasonability in the decision, so it doesn't have to be very correct. The court should not substitute its own decision with that of the administrative decision maker or the First Nation people. If the First Nation people have made a decision and it is being challenged, once that decision is logical, is reasonable, you can see some level of faults going into that decision, then that should be upheld, and the court should not just overrule the decision only on the basis that it will have arrived at a different decision. Yeah. So the Desertel case relates to the limits of the exercise of Aboriginal rights. That to say, Section 35 of the Constitutional Act of 1982, when it says that the right of the Aboriginal people is hereby recognized and affirmed, does it relate just to Aboriginal people living in Canada? In that particular case, very interesting case, an Aboriginal that lives in the US came to Canada to fish, and he was arrested. That it was in BC, to say it was prohibited to fish on that particular river. So he was arrested, charged to court, and all that. And he said, "Oh, I'm an Aboriginal, and by virtue of the Constitutional Act of 1982, that my fishing rights and is protected by the Canadian Constitution." So the question now arose that this gentleman is not a Canadian. Can a non-Canadian can they assert Aboriginal rights? And the Supreme Court of Canada now says yes, non-Canadian can assert Aboriginal rights in Canada to the extent that they can establish that they are Aboriginal. So so for example, maybe their great grandfather and what have you were Canadians and they lived around that area, but due to modernization and drawing of boundary and all that, their own boundary now falls outside of Canada. So the court said that that is not a bar for them to claim Aboriginal rights and title. So they can always claim it once they can establish roots to Canada, whether through their parents or grandparents or great grandparents. And the article, whose sovereignty is it anyway, is elaborate on that case as well. So yeah, I mean, long reading in chapter 2, but it's is quite interesting, all leading to the fact that of the special nature of the Aboriginal people of Canada, and the fact that their rights and title need to be respected, and the fact that the treaty entered with them need to also be respected. The government has to deal with them as fiduciary. They have to deal with them in good faith and what have you. So so the case of Newfoundland and Labrador versus Ushanot, I think that was the one I was trying to remember, to say that when you are dealing with Aboriginal matter, the court will not consider technicality. So what is most important is the substance of that case. So and the court will put technicality to a secondary level. It won't be the most important consideration of the court. So in the Silk Cotton Nation versus BC as well, it deals with proof of Aboriginal title. So how do we establish proof of Aboriginal title? We mentioned earlier that once they can trace their history to the land and to the fact that they use the land for their cultural purpose, or for farming, for fishing, or they even pass through that land to an adjoining land, that is enough to prove Aboriginal rights. So, and the court doesn't really rely on technicality, so to say. So in the case of Daniels and Canada, so the court held in that case that Aboriginal includes both registered and non-registered Indians. So even while in the determination of whether a person can claim Aboriginal right or Aboriginal title, whether or not the person is registered under the Indians Act or is not registered, it doesn't really matter. It applies to both of them, you know. So in Brown and Canada as well, which is the courts held that the common law, that the Crown owes Aboriginal duty of care. You know, that's the fiduciary duty that we've been talking about since. That it's also that common law duty of care is also owed by the Crown to the Aboriginal people as well. So the other two cases that you find in the syllabus, yeah, so okay, one actually under Aboriginal treaties, the Restore and Canada, and the article Historical Lawsuit Affirms Indigenous Law on Par with Canada. So the article explained that case, which is what I mentioned earlier regarding the payment of royalty, so for the use of Aboriginal land, to say that the Aboriginal people, they are entitled to further negotiation with the Crown in terms of reviewing the royalty that is payable, and it's part of the duty of the Crown to negotiate with them in good faith. You know, so that's the summary of chapter 2. Can we proceed to chapter 3? Any questions so far? Or am I just talking to myself?
None so far.
None for me.
Your
Okay.
discussion was very good. Thank you.
Okay.
Thank you very much.
Okay. Thank you. I just need that confirmation, so I'm sure that we are flowing on the same page, and I'm not just talking to myself. Okay.
Yes.
So thank you. So chapter 3, yeah, the sources of Canadian law. You know, this we should be familiar with the sources of Canadian law, the common law and civil tradition. You know, and like I mentioned at the beginning, if you've done while going through the university system, one of the first thing they will tell you is sources of law. And as most of us, or all of us, I imagine, are from common law jurisdiction, so it's the same sources that that is in our own jurisdiction that also form part of the sources of Canadian legal system, with certain differences, of course. So one of the first things that we should note is that Canadian state is a bijurial state, you know, meaning that it combines tradition or legal tradition from different areas. So in the context of Canada, we have the common law tradition and the civil law tradition. So the common law tradition, obviously based on the common law of England, right? While the civil tradition is based on the French civil code. And you find the French civil code is, applicable in Quebec, you know, so the civil law of Quebec, while in other provinces, it is the common law that is their own tradition. So at the federal level, for example, we have the common law operating at the federal level, you know, while at the provincial level, we have common law operating in every other provinces except Quebec, you know. So what it means, therefore, is that in Quebec, you have both the common law operating and the civil law, because federal law is still applicable in Quebec, and the tradition of Quebec is civil. You know, at the provincial level in Quebec, the civil law operates, while at the federal level in Quebec, federal law or common law tradition operates. You know, but in every other province, both at the federal and provincial level, it is the common law that is operating. So the chapter talks about the reception of the European law, so how did the European law even come into force in Canada, so in certain parts, it was received, so for Quebec, for example, it was conquered, Quebec was conquered because the European fought the French, and at the end of the day, they reached an accord, so so the reception depended on whether colonies were settled or they were conquered. So for every other place except Quebec, they were settled, while for Quebec it was conquered. In where in colonies that settlement took place, the common law of England was just imported directly, as it is in many of our common law jurisdictions. So the common law of England, doctrine of equity, or at a particular date was doctrine of equity at that time, and the statutes of general application at a particular date were all imported into the settled colonies, and just local custom, to the extent that they are not repugnant to the principle of natural justice, equities, and good conscience, were left for settled colony, while for conquered provinces or colonies like Quebec, civil law remained, because they had civil law at that time. So they did not uproot it. So they just allowed them to continue to operate their law as it was at a particular point in time. So so the other things to note as well is the international law as a source of Canadian law. So we've talked about common law, we've talked about equitable doctrines, right? And we've also talked about Civil Code of Quebec as applicable in Quebec, and we also mentioned that at the tradition at the federal level is common law. As the other 9 provinces, the tradition is also common law, but Quebec, it is at the federal level is common law, while at the provincial level is civil tradition that operates. So those are sources of Canadian law. So in addition is international law. So customary international law are part of Canadian law. So because customary international law are part of common law, so they also automatically form part of Canadian law without any need to domesticate those customary international law. For treaties, they do not become law until they are domesticated. And the recent treaty that was domesticated is the UNDRIP, United Nations Declaration on rights of Indigenous people. So that is the most recent treaty that was domesticated in Canada. So treaties do not automatically form part of the Canadian legal system or sources of Canadian law. They have to be domesticated. So the next topic discussed is bijuralism. I think we've also talked about that, so which is about the existence of 2 legal traditions in the same legal system. So in respect of Canada, we have both the civil code and the common law, or civil tradition and the common law tradition. So the next thing that we'll talk about here is the statutory law. Those are just law passed by the Parliament, which automatically form part of the law of Canada. International law, I think we've also talked about them, to say customary international law, they form part of sources of law in Canada, but treaties and all that, they do not form part of the law until they are domesticated. So in terms of the course materials, so again, Forces Chapter 4, then Grimald and Canada. That case, very interesting case, talks about the influence of common law and civil tradition, the interplay within them, to say that at the end of the day, while common law is a source of law in Canada, and civil law is also a source of law in Canada, there is no strict or watertight compartmentalization between the two laws. Both of them relate with one another one way or the other, such that in many instances, the civil law relies on doctrines of common law in interpretation. So that's the what that case is talking about. Then in Qatar and Canada, sorry, not Qatar and Canada now. I will Deborah Parks, which talks about precedent revisited, Qatar and Canada and the contemporary practice of precedent. So that article analyzed the decision in Qatar and Canada among other cases as well, basically saying that we should not look at precedents as a source of law. Should not be we should not take a dogmatic view of precedent as a source of law, that we should rather look at the practice of precedent to say that precedent will guide us to determine how the court interpreted cases over time, and we should look at it as a practice as opposed to just source of law simplicity. In the case of Qatar and Canada, for example, the court held that the court overruled a lower court. Let me put it this way: a lower court refused to follow a decision of a higher court. We all know that based on the principle of judicial precedent or stare decisis, a lower court is always bound to follow the decision of a higher court, whether or not the lower court agrees with the decision of that higher court. But in that Qatar and Canada, the lower court refused to follow the decision of a higher court, and the Supreme Court upheld that decision of the lower court to refuse to follow the decision of a higher court. And that is because there was a change in circumstance, to say that if we should not blindly, a court should not blindly follow the decision of a higher court. It should look at the ratio of the case. It should also look at the circumstance of a particular case in time, and that trial judges can depart from precedents where there is a new legal issue, where there is a change in circumstance that fundamentally shift the parameters of the debate. So the court should take cognizance of those in analyzing a precedent. I should not just say, oh, the higher court has said this, then I must follow it. So the court must always look at other circumstances. So if there is a new legal issue, if there is a change in circumstance and what have you, the court should feel free to deviate from the decision of the higher court, and we would consider that in greater details in the intensive class. So another article that the chapter talks about is analogical reasoning. Very interesting. This article was was taken out of the syllabus in 2020, I think. Then it was brought back again. Interestingly, when it was in the syllabus, it was under chapter 1. Now they've brought it back under chapter 3. So again, what the just summary of the article is that analogical reasoning is how a lawyer thinks, you know, and it's relevant in the context of judicial precedent to say when a lawyer is trying to analyze a case, it uses analogical reasoning to say that the court held like this in a case that has similar facts with this my case. Therefore, the court will most likely follow the same reasoning in my case. You know, so that is how a lawyer usually reason. And he says that, look, in this, you know, the conventional method of a lawyer, it simplifies things because you are looking at principled consistency, for example, to say once the court has established a principle in a particular case, any fact that relates or that is similar to that case, the court should be consistent in applying those principles to those facts. Then it also enables you to focus on particulars, and it also relieves you of the pain of trying to form a theory, you know, and just makes your life easier, you know, when you apply analogical reasoning. But again, it says that it is not at all times that analogical reasoning works, you know, which is why I think it's relevant to this discussion on judicial precedent, or to say it's not at all times that analogical reasoning works. There are other times that you have to apply other form of deductive reasoning to arrive at a decision, and is relevant where a lower court is deviating or refusing to follow the decision of a higher court by looking at what are the new legal issues that have arisen, what are the change in circumstances that have also occurred, such that there will be a basis to deviate from the decision of that higher court. So another article that we'll talk about is equity as meta law. Yeah, it's also one of the new articles introduced in the course materials. So, and again, the article chronicles how the merger of common law with equity, you know, to say now that merger is complete, you know, such that we don't necessarily see a difference between the doctrines of the common law principles and equitable doctrines. We don't necessarily see a difference, but he emphasized the fact that equity, notwithstanding the merger, is still very distinct from common law, in the sense that in areas where common law do not provide remedy, we've seen equity providing remedy. And also in our consciousness, when you are analyzing a statutory provision, or when a judge is dealing with a particular situation, you know, what gives the judge flexibility to apply things outside the strict provision of the law is that doctrines of equity, you know. So when the court is interpreting charter, for example, you know, the court has wide powers to infuse or certain things so as to achieve what they believe is the intention of the parliament, and the things that enable that gives them that latitude is usually equitable doctrines, not just the law stricto sensu, you know. So that's what the article is talking about. Baker and Canada as well. For those that have done admin law, you will see Baker and Canada. But here the emphasis really is on the whether international law that have not been domesticated form part of Canadian law. You know, so and the answer, of course, is no. Until they are domesticated, they do not form part of Canadian law, while Canadian courts are enjoined to take judicial notice of certain international treaties, you know, but in stricto sensu, if they've not been domesticated, then they will not form part of Canadian law. In Aaron Hape, you know, so the decision of the court in that case was around whether charter applies whether charter applies to activities of Canadian government officials outside of Canada, whether charter has extraterritorial application. So I think the case was about search and seizure in outside Canada, and the court held that the charter does not generally apply to searches and seizures in other countries. That so what applies is so if Canadian officials are searching are conducting a search on someone outside Canada, what will apply to them is the law of that country, you know, so not charter principles, you know, so things that may be searches that may be deemed unconstitutional in Canada may be constitutional in other countries, and the court in that case held that once the search complies with the law of that other country, then it is generally fine. Or on the other side, in Nelson Resources Limited, which is a Canadian company, versus Araya, some Eritrean workers sued that Canadian Canadian company who was operating outside Canada. They sued them in BC to say there was a violation, the operation of that company in Eritrea violated certain Canadian human rights laws and all that. So the argument of the the company Nelson was that they were operating outside Canada, and based on the Act of States doctrine, the doctrine of Act of States, Canadian law does not apply to them. But the court disagreed and said that the Act of States and its underlying principles, they are not a bar they do to people bringing an action against a Canadian registered entity in Canada. That the Act of States does not play any part in the operation of the Canadian law, such that once that entity can be brought under Canadian jurisdiction, in this case, that the company is registered in Canada, then the if they've violated any law that will have been applicable to them if they were in operation in Canada, then the court has jurisdiction over them. So we'll deal with that in details and the distinction between it and the previous case in our intensive class. So yeah, we've let's quickly go to chapter 4 and we'll run through it. We're running out of time already. So chapter 4 talks about fundamental principles of Canadian legal system. So the rule of law, constitutional supremacy, parliamentary sovereignty, federalism, separation of powers, and judicial independence. So those are the principles underpinning public law in Canada. So what does rule of law mean? It just means that every act of the state has to be based on law. You know, any executive action has to be validated based on law, you know, and that everyone is subject to the law. You know, that's basically what the rule of law means. So constitutional supremacy means that the constitution is the ground norm, that and that every other law is subject to the constitution. Previously, we should know that previously, Canada operated a parliamentary supremacy, meaning that the parliament can pass any law that they wish. But now, based on section 52 of the Constitutional Act of 1982, it is now parliamentary action is now is now subject to the Constitution. So, in other words, while Parliament can make any law, it has to be subject to the Constitution. So the powers of the Parliament is only limited by the Constitution, you know. So that's what constitutional supremacy talks about. Basically, Section 52 of the Constitutional Act of 1982, which says that the Constitution is supreme. Then parliamentary sovereignty, of course, says that the Parliament is the most preeminent arm of the government, if we can say it that way. So, and that you cannot um, any action of the executive that interferes with the sovereignty of the Parliament it will be unconstitutional, and the Parliament can make any law that suits the Parliament. The law can be good law, it can be bad law, it can be moral law, it can be immoral law, any law whatever. The Parliament has the power to make the law. And a related concept to that is the power of the Parliament to sort of exclude strangers from its proceedings, to make its own rules and regulation without interference from the court. And we'll see in subsequent cases, I think in Duffy and Canada, where the where the Parliament suspended a member of the Senate, and the member sued the Senate, and the court held that, look, anything that has to do with operations of the Parliament, it is outside the power of the court to deal with, you know. So the other concept of Canadian legal system is federalism. So meaning that Canada is a federation, you know. So, and that federal principle has to be respected. So we have the federal and the provincial government. So the federal government and the provincial government. So the federal government has the Parliament, which consists of the Senate and the House of Commons, which makes law for it, while we have legislative assemblies for each of the 10 provinces in Canada, and there are certain powers that are attributed to the Parliament. I think Section 91 speaks to the powers that have been allocated to the Parliament. That the Parliament has exclusive jurisdiction over those matters, and also Section 92 talks about the powers that are given to the provinces, so and that division of power is there. So exercise powers that have been devolved to the Parliament and powers that have been devolved to the provinces. Of course, there is the argument that undue power has been given to the federal government, in the sense that even powers that were given to the state government the provincial government is still sort of subservient to the federal powers, and you will see where the federal government sort of encroaches on the powers given to the provincial government. For example, let's take property and civil rights, for example, which is a power given to the provinces, or trade and commerce, So, and you will see interplay is interplay the right word, or sort of overlap. Okay, I think overlap is what I wanted to remember. So overlap between the two arms of government, where in these areas you see things that are property and civil rights. You see the federal, which is a provincial power, but you see the federal government exercising certain powers which are property and civil rights. So trade and commerce, for example, is a power given to the federal government. So but the federal government exercises certain rights over in exercising its trade and commerce right. It overlaps the power of the provinces to on civil rights. So I will see a lot of the interplay I explained more in constitutional law, but for the purposes of foundations, we don't need to dig that deep, but just to know that Canada operates a federal system of government where powers are given to both the province and the federal government. They are enumerated in both Section 91 and 92 of the Constitutional Act, but sometimes there is this overlap between the two level of government. So another principle which is related is separation of powers, right? So separation of power between the executive, legislature, and judiciary. But we also mentioned earlier that there is a fusion in Canada. There is a fusion of power between the executive and the legislature, in the sense that members of the executive are also members of parliament. In fact, the cabinet, for example, is all cabinet members are members of parliament, because the prime minister forms the cabinet on the basis of choosing from members of parliament. So when they sit in parliament, they exercise legislative power. When they are sitting in the cabinet, they're exercising legislative power. But notwithstanding, there's still separation of power between when they exercise legislative power or when they're exercising executive powers. So of course there's the judiciary as well, which is also a separate arm of government from the other arms of government. So the other principle is judicial independence, which talks about why related to separation of power rights, and saying that the judiciary must be independent in every respect, in terms of appointment of judges, in terms of their decision making, and in terms of their remuneration and what have you. There must be independence. So financial autonomy, administrative independence, and all that, those are reflected in judicial independence. So very quickly, I go to chapter 5, so which talks about the parliament and its components. So the monarch and the governor general, the Senate, House of Commons. So the Parliament of Canada, and when you hear parliament, is the federal government that we are speaking about. They use legislative assembly for provincial governments. So for the parliament, you have the monarch, which is the queen. So the queen of England is still the queen of Canada, and the governor general. So the governor general, the queen exercises her powers through the governor general. So in terms of the parliament, the composition of the parliament includes the queen. And also note that the queen is the head of the executive, and she's also part of the parliament and head of the parliament as well. Because when a law is passed by the parliament, it has to be signed into law before it becomes effective. It has to be signed by the queen, and the queen does that through the governor general. So so the queen is part of the parliament, right? Then the Senate, we have the upper legislative and the House of Commons. So the Senate is the upper legislative arm, and the peculiarity of Canada's Senate is that it is an appointed Senate. So members of the Senate are appointed by the Governor General, obviously on the recommendation of the Prime Minister. So the Governor General is not going to just appoint anybody, but by constitutional convention, and we'll deal with constitutional convention. We'll talk about it, but constitutional convention is dealt more under constitutional law. So we won't focus a lot on it in foundations, but just to note, what is relevant here is that the Canada Senate is an appointed Senate. It is not elected, and the mode of appointment is by Governor General on the recommendation of the Prime Minister. Then the House of Commons, that is now the elective position. So so they are the more active one, because they are elected by the people. So when there is an election and what have you, election is usually into the House of Commons, and there is a way it is divided among within the provinces. I think Ontario has the highest number of members in the parliament, so, and other provinces as well have certain numbers that have been allocated to them, and all that. So here we reforming the Senate of Canada. The article that is under this chapter is reforming the Senate of Canada, frequently asked questions. So this article basically talks about having whether we should have an elected Senate or not. We mentioned that in Canada, the Senate is members are appointed into the Senate. So so basically the article talks about the imperative of having an elected Senate, why Canada doesn't have an elected Senate, why it has an appointed Senate, whether female can be appointed into the Senate, whether there should be tenure for people or for senators, whether changes in the constitution, in the composition of the Senate, whether it requires constitutional amendments, So I think section 42 or 43 deals with amendment of the constitution. So that's the Constitutional Act of 1982. Then section 42 or so deals with amendment of the constitution. And one of the debates is whether, if you want to change the composition of the constitution, whether whether it requires amendments to the constitution, and if it does, what is the amendment procedure? So those are the things dealt with under that article. So chapter 6, am I communicating so far? Any question, comments, anything?
None.
No, not for me.
Okay. Are we following though?
Yes, we are.
Okay.
Absolutely.
Thank you. So functions of parliament, so Duffy and functions of parliament. What does the Parliament of Canada do? So this is quite a straightforward topic. So summoning is just to call on the Parliament to commence the session of the Parliament. Then prorogation. So when the Parliament is summoned, they are divided into each session of the Parliament is divided by a prorogation. So meaning that the Parliament can open, and when the Parliament goes on recess, that is a prorogation of the Parliament. So prorogation is also used in terms of suspension of the sitting of the Parliament. So, and I know for those of us familiar with the politics of Canada, I think in 2020, the Prime Minister Justin Trudeau prorogued the Parliament, meaning that he suspended the sitting of the Parliament. So he was under investigation at the time, I think there were some charity that his government, his family members were involved in, which the government of Canada donated to and what have you. So there was investigation by the Parliament to say whether there was inappropriate or wrongdoing by the Prime Minister at that time. So very close to the conclusion of the sitting of those parliamentary committees, the Prime Minister requested the Governor General to prorogue the Parliament. So it's not the Prime Minister himself that prorogued the Parliament, it's the Governor General that does it, but it will be by constitutional convention, it is on the request or at the request of the Prime Minister. So the effect of prorogation is that when a Parliament has been prorogued, any law that has not been concluded, will be suspended. It has to be started afresh. If a sitting or if an investigation has not been concluded, then that investigation, that committee has been dissolved, because prorogation basically dissolves all the committees, and an investigation that has not been completed will go with that prorogation, which is why that's, I have referred to that event of 2020 when the Prime Minister prorogued the Parliament or requested the Governor General to prorogue the Parliament. So that was how that was it called, that investigation into that charity matter ended. So the debate that you usually have around prorogation is whether the Governor General can refuse the request of the Prime Minister to prorogue the Parliament. So by law, he or she can refuse, but by constitutional convention, and constitutional convention is a very strong unwritten principle of the constitution in Canada, in the sense that, yeah, like we know, convention is not written anywhere, but that is what, more than anything else, dictates the functioning of government in Canada. So, so based on prorogation by constitutional convention, yes, the governor general can refuse the prorogation request. Sorry, not by constitutional convention. By law, the governor general can refuse the prorogation request of the prime minister, but by constitutional convention, he doesn't, or he or she doesn't. I mean, except in very exceptional situation where, for example, the parliament, the prime minister has lost control of the parliament, and it is clear that a vote of no confidence will be passed on the prime minister. In that situation, where the governor general, where the prime minister requests the governor general to prorogue the parliament, the governor general will usually refuse, and I think that has happened in one or two occasions. But other than that, by the governor general really is just a rubber stamp. It will follow whatever the prime minister requests. So, dissolution of parliament. The lifespan of parliament is in Canada is 5 years, so it cannot exceed 5 years. So and once it is 5 years, it becomes automatically dissolved. But there can be a dissolution prior to expiration of 5 years. For example, if a vote of no confidence is passed on the prime minister, so that's usually automatically dissolve the parliament, and there will be a call for a new election. As we know, the leader in Canada, the leader of the party is usually, or yeah, is the it becomes the leader of the party that wants majority seats of parliament becomes the prime minister. So if that party, if that leader loses the confidence of his party, then a vote of confidence, a vote of no confidence can be passed on the prime minister, and another election would have to take place, and that parliament will be automatically dissolved. So another point there is key actors. So the key actors in the parliament are the speaker of the parliament. So the prime minister is not the head of the parliament, is just the head of the executive, right? So the head of the parliament will be the speaker, who sort of organizes proceedings in the parliament, calls for sitting, and all those kind of stuff. And you also have all the other characters, majority leader, minority leader, the different political parties, the members of the parliament, and all those are the key actors in the parliament. So another point discussed there is parliamentary procedure and lawmaking. So this just basically talks about how law is made for first introduced by an arm of government, or so for example, any law relating to spending or currency and what have you can only be introduced by the executive. So not individual members cannot introduce those kind of bills. So things like that are what are discussed in chapter 6. I will not go through the cases. I think I've talked about Duffy and Senate earlier. Shannon and syndicates, I will not go through them, but basically they are talking about the sovereignty of the parliament, the power of the parliament to exclude strangers from its sitting, and all those kind of sovereignty or incidences. Yeah. So chapter 7 the executive and its functions. So we've talked about the parliament in chapter 6. So chapter 7 is executive and its functions, and we mentioned earlier the fusion of executive and legislature in Canada, right? So functions of the executive include, yeah, I mean, as the name suggests, enforcement, the rule making as well is part of the functions of the executive. Um, so certain executive also adjudicate. So administrative bodies that are set up by the executive, they also, for example, the immigration board is an executive. They also adjudicate. One of the functions of the executive as well is determination of rights and obligations. So they issue licenses, whether driver's license or medical license or and things like that. So they also provide services, such as education, uh, cleaning of or development of road or infrastructure generally, and all that. So those are some of the uh, uh, um, functions of the executive. So in terms of sources of executive power, so the first, of course, is the Constitution, of Canada. Then again, the statutes, laws passed by um, by the parliament. Another very important source of executive power is prerogative power. So and prerogative power are powers that they are residual power, so to say. So traditionally, executive used to, before we had division of power into executive, legislature, and judiciary, executive used to exercise all the powers, like look at a traditional king. The king is, I mean, he makes laws. When there are dispute, everyone comes to the king. He adjudicates, and through its chiefs, the king executes as well. So any power that has not been taken away by either the legislature or the judiciary are prerogative power. So those leftover or residual powers are exercised by the executive. So here as well, we'll talk about, I mean, the reviewability of the decision of the executive. What can be reviewed? Can policy matters, for example, can it be reviewed by the judiciary? So things like that, we would deal with them. So the confines of review of executive powers. So very quickly, I'll go to chapter 8. So we are nearing the end now. I think in another 10-15 minutes we should be over. So the court and the judiciary, the structure of the Canadian court system, judicial appointments, judicial independence. So what we should note here is, here we'll deal with hierarchy of court. So at the top, of course, is the Supreme Court of Canada. Then at the followed by that is the Court of Appeal of each of the provinces. So each of the provinces have Court of Appeal, and appeal from those Court of Appeal go to the Supreme Court. Then we have the Superior Court of the provinces. So those are the court of inherent jurisdiction, so to say. They have wide powers and exercise different jurisdictions in different forms. So beneath those superior court of the provinces are provincial courts. So provincial courts are courts established by the provinces themselves. So the other court, the Superior Court of the Provinces, is the federal government pays appoints judges in those Superior Court of the Provinces, and they pay the salary of those judges and all that, and those superior courts are managed by the provincial government, but the appointment of the judges and the salaries of judges are paid by the federal government. So they are called section is it section 1 is it section 100 or 101 courts? There is a name they call them, but basically because it is that section of the constitution that deals with the constitution of those courts, that's why they are called section 100 or 101. I can't remember the section courts, but the point to note there is that the salaries of those superior court of the provinces are paid by the federal government, and the appointment, promotion, and what have you is also done by the federal government, while that of the provincial courts is done by the provinces, and the provincial courts, they deal with generally all most of the cases, most criminal cases are done at the provincial court, so, and it is and they are courts of limited jurisdiction, so they do not have inherent jurisdiction like the superior courts of the provinces, so an appeal from those provincial courts go to the superior court of the provinces, then from there to the court of appeal of the provinces, then from the court of appeal of the provinces to the superior or supreme court rather. Then side by side with the superior court of the provinces, we also have superior courts that are established by the federal government itself. So they are called the federal court, right? And we also have federal court of appeal, which is also entirely done by the federal court. So we also have tax courts, which deal with tax matters and what have you. Those are the structure. I mean, in brief, there are some nuances here and there, but in brief, that is the structure of the Canadian court system. So appointment, yeah, we dealt a bit with the appointment in terms of the Superior Court of the provinces. I mentioned that the Superior Court of the provinces are constituted by and managed by the provinces, but the appointment and salary of judges are done by the federal government. Yeah. So then related to appointment as well is judicial independence. So there is this debate that if the executive is the one appointing the judges to the court, how can we assure their independence? So and again, the conclusion is that while in the appointment of the judges, there is no really independence in the appointment of the judges, but once they become judges, then they are guided by a different consideration altogether. So, and there has to be independence in terms of their finances. So there has to be financial autonomy. Then there has to be administrative independence as well. And there is a third arm of independence. I'm trying to remember now. I think is it in their discipline or so. So yeah, in their finances, there has to be autonomy in the administration of the court. There has to be independence as well. Yeah. So I will go to chapter 9 now. So chapter 9 talks about statutory interpretation. So, and the approaches to interpretation and the modern approach to interpretation. So, what it basically says is that in interpreting a statute, you know, the court should take everything into consideration. So the court should not just look at the code letters of the law. The court should look at the circumstance of the case, the prevailing condition in the society, and all the contexts of an issue when interpreting a statutory provision, and that is the modern rule of interpretation. Previously, the court used to apply static rule or literal rule and all that to say, okay, the law has said, the law has written, that's how we are going to interpret it. You know, the law has said what it means, and it means what it says. So in interpreting in interpreting a statute, the modern approach is now that the court should take cognizance everything, all the circumstance of the case or of the issue or of the matter before coming to a decision. And we'll delve more on that in some problems with shared meaning rule as formulated in R versus Dowst. So shared meaning talks about the meaning of a statute, whether it is written in English or in French. That is what that deals with. So the last chapter, chapter 10, so is a judicial review in a democratic society and judicial review of administrative action. So basically, it's talking about how the court should review decision made by administrative tribunal or administrative decision makers. You know, we know that those so let's say an immigration board, for example, or a tax board, or an education board, a school board, when they make a decision, how should the court interpret or intervene in that decision? So the thing to take away here is that in reviewing those decisions, the court should recognize that the parliament has empowered those boards to make those decisions. If the parliament wanted to empower the court to make the decision, it will have shifted that power to the court. But the parliament has empowered those boards to make the decision, and what should guide the courts is doctrine of deference, to say, except this decision is absolutely unreasonable, that is when the court should overturn that decision of the administrative body. To the extent that a reason can be found in the decision of the administrative body, the court should, as much as possible, uphold the decision of that administrative body and give and defer to the administrative body. You know, and in the case of Vavilo, for example, it was held that the applicable doctrine or the general rule is that what should guide the court is reasonability. So once the decision is reasonable, the court should just defer and not overturn. It should uphold that decision of the administrative body. So except in constitutional matters, for example, where the doctrine of correctness should be the basis of review, and also where the law has specifically stated that the standard of review should be correctness. In every other case, or in all other circumstances, the general rule or the default rule is that the court should defer to the decision of the administrative body, and that's basically what that chapter is talking about. So there are cases there: Brown and Canada, Shutterwood and Ontario, Highwood Congregation and Jehovah Witness, and all that. So also basically talking about whether it is every decision that is reviewable. You know, there are some certain decisions that do not lend themselves to being reviewed. You know, so in those kind of I'll give you an example of the Highwood Congregation of Jehovah Witness case, which was a member was suspended by the Jehovah Witness, and he approached the court to say, reverse my suspension. And the court said, look, we are not the appropriate forum to deal with this kind of issue. Whether you want to be a member of a particular society or not, has to be governed by the rule of that society, and it is not in the place of the court to determine whether someone should or should not be a member of a particular society. And and Vavilov as well is about the decision of an immigration board and what have you, and the courts ruled that, I mean, the basis for review of the decision of an administrative body should be reasonableness, except in certain circumstances like constitutional matters, or where the statute has specifically provided that it should be reviewed on the basis of correctness. And after the courts find that decision is unreasonable, depending on the circumstance of the case, the court should either remit the case to the administrative body so that it can arrive at the proper decision, or in circumstances where it will not be necessary, like in this case of Vavilov, that it wasn't necessary to remit the case back to the administrative body, the court can now come to a decision on the matter and not necessarily remit it to the administrative body to take a decision. So that's the overview of chapters 1 to 10 of the syllabus. Of course, I mean, like the name suggests, an overview. A lot of details are contained in the material, a number of articles, a number of cases, and what have you. And we would be able to deal with all those in our intensive class when we'll have more time and opportunity to go through them one after the other. Usually our intensive classes we take 4 classes of 3 hours each, you know. But what we have seen in foundations is that we usually do supplementary classes because of the depths of the topics as well, just to ensure that we are all good and feel comfortable going into the exams. So we can say that we'll take about 5 or 6 classes, you know, of the foundations, depending on how fast we are able to go. And there will also be one examination review class, you know. So I think that's usually for 2 or 3 hours as well, where we go through questions, past questions that have been asked previously, and just general questions that people may have, and how to approach the examination and all that. I'm aware that the exam is now changing to, is it 3 hours from January? So when the pandemic came, they increased it to 4 hours, because the technology was new, and everybody was trying to get familiar with the process. but now they've reverted back to the 3 hours. But we'll see how that goes. So that's it from me. I don't know if we have any question, comments, clarification, anything.
Personally, I don't know.
Okay, so did you find the classes or the class useful or
Yes, so it was very useful. Actually, it's my first class on admin, right?
no foundation?
I'm sorry, foundation. So, but
Okay,
I have to be honest at this point. I understood every bit of what you taught. And I want this opportunity to say thank you so much. I really appreciate.
no worries. You're welcome. Any other comments?
Would just like to thank you for the very clear overview.
Thank you, Abigail.
Hi. Well, just as I suspected, it's a lot, like compared to admin. I wouldn't say it's a lot, but there's a lot more reading. But I feel like now I have like a clear path, and it doesn't seem so daunting anymore. So we should be able to take it from here. So thanks.
Okay, sounds good. I will say thank you again for attending the class and please take care.
Thank you. Bye.
Thank
Bye
you
bye.
so much. Bye.
Thank you very much. Thank you so much.
No worries at all.
We are NCA's guides.
Every year, a significant number of foreign trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examination.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present, and we help candidates overcome these difficulties and obstacles in understanding the course materials and the exam formats.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a great track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.